Friends, in course of the study of various aspects on human rights, today we shall deal with judicial response to the protection of human rights during emergency. To start with, judiciary is the custodian of rights of individuals. The power of judicial review has been explicitly established under the Constitution of India. The same has been proclaimed as the basic features of the Constitution. So, the power of the court is firmly rooted under the Constitution of India, which is per se an indispensable means to protect human rights of citizens and individuals, inter alia to maintain rule of law at all time, even during the state of emergency. A proclamation of emergency under Article 352 of the Constitution will result into maximum abridgment of the human rights which are guaranteed under the normal times. The right to life and personal liberty is at stake. By making the judiciary feeble and weak to enforce the right during the period in which a proclamation of emergency is in operation, people are disabled in case one desires to seek redressal to enforce right to life and personal liberty by taking recourse to law. It is one of the most important fundamental rights of individual with which one has the right to move the Supreme Court for the enforcement of any of the fundamental rights that is guaranteed under Part 3 of the Constitution by taking recourse to Article 32 of the Constitution. But when a proclamation of emergency arises out of war or external aggression, by virtue of Article 358 of the Constitution, the 6 freedoms guaranteed under Article 19 are automatically suspended. Further, under Article 359, the President may by order suspend the right to move any court for the enforcement of any or all the fundamental rights as indicated in the order. Although after 1978, the power of the President to suspend Article 20 and 21 has been taken away by the 44th Amendment of the Constitution, the Executive may still exceed the power by making enforcement in the human rights. Preventive detention means detention of a person without trial and conviction by a court, but merely on suspicion in the mind of an executive authority. Preventive detention is used in countries like England and Canada, but only during the war time and not during peacetime. In India, preventive detention is used even in peacetime to cope up the unstable law and order situation in the country. Clauses 2 to 7 of Article 22 of the Constitution lay down the special rule of preventive detention and also provide for minimum safeguards to be observed in preventive detention matters. In the year 1975, when proclamation of emergency was declared, owing to internal disturbance, a presidential order was issued under Article 359, suspending enforcement of the rights of any person under Article 14, 21 and 22 generally. At the relevant time, the law of preventive detention in force was the Maintenance of Internal Security Act 1971, for short MISA. The Act was amended for the preventive detention cases as in: firstly, the grounds of detention were not to be communicated to the detainees. Secondly, the case was not to be reviewed by the advisory board as envisaged in Article 22 of the Constitution. And thirdly, the detainee was not to have the right of making a representation against the detention order. In the matters of judicial response to the protection of human rights during a proclamation of emergency, one cannot keep aside and ignore the sad case known as fundamental right case, as the Attorney General argued on behalf of the Union of India that during the emergency, the executive did not invite the court to examine the validity of such an action. Therefore, the right to life during a proclamation of emergency requires an analysis. There were 3 proclamations of emergency issued by the President of India under Article 352 since the commencement of the Constitution. The earlier 2 had been necessitated due to the Chinese aggression to India in the year 1962, and the other was due to war waged by Pakistan against India in the year 1971. The third instance of proclamation of emergency was on the ground of internal disturbance in the year 1975. In all the 3 instances of proclamation of emergencies, the right to move any court for the enforcement of the right guaranteed under the fundamental right. For instance, Article 21 was suspended by an order of the President. Reading the provision of Article 359, the presidential order may have the effect of suspending the right to move the court for enforcement of the fundamental rights indicated in the order, but such an order cannot suspend the rights themselves. The rights do exist as before the emergency, but in case a person desires to enforce such a right when the proclamation of emergency is in operation, he cannot enforce the right to move any court for the enforcement of such a right, and is therefore suspended for the time being. M.P. Jain, an eminent constitutional law expert, in his book Indian Constitutional Law, has remarked that the provision of the amended MISA covering emergency detention were extremely drastic, and India has never before witnessed such a rigorous version of preventive detention. He has remarked that a stone wall was created around the grounds of detention, and the provisions were so drafted to exclude judicial review of any case of emergency detention. A.S.P. Sathe, another constitutional law jurist, in his book Judicial Activism in India, remarked that although the Supreme Court of India became the most powerful apex court due to its power to invalidate even a constitutional amendment. Its institutional weakness was ultimately revealed through its decisions in the fundamental rights case. According to him, liberty survives even though right to life and liberty under Article 21 is suspended during a proclamation of emergency. The jurists have pointed out that the judicial response to the protection of human rights during emergency is poor. It has been opined that during emergency, the court could not stand up against the executive on its own. While Article 352 affects fundamental rights, Article 356 does not. Therefore, in the case of President's rule, there is no fear for violation of human rights. The enforceability and maintenance of human rights remain unchanged as before the emergency is in operation under Article 356 and after. In the case of financial emergency, if issued, then there is possibility of encroachment of human rights for those who are in the state and central service, as it shall be competent for the President to issue directions for reduction of the salaries and allowances for all or any class of the persons serving in connection with the affairs of the state and the union, including the judges of the Supreme Court and the high courts. However, when emergency under Article 356 is in operation in the State Assembly, the State Assembly ceases to function. The laws for the state are to be made by the Parliament, and the Governor administers the state on behalf of the President. Here, the right of the people of the state to be governed by their elected popular government ceases. In this sense, imposition of the President's rule has the effect of encroachment of rights of the subjects of the state concerned, whose powers have been assumed by the President. Several attempts were made from time to time to bring the imposition of the emergency under Article 356 before the court for scrutiny, but such attempts proved to be futile. The 44th Amendment 1978 has again removed the bar on judicial review of the presidential action, which was inserted by 38th Amendment Act 1975. The 44th Amendment Act 1978 has virtually acknowledged the non-derogability concept of human rights even during the proclamation of public emergency. Therefore, judicial review of the presidential action in emergencies can be made, and there is no prohibition in the judicial review now. Friends, we can conclude by mentioning that while considering the matter of judicial response to protection of human rights during emergency, it is found out that high watermark of legal positivism is expressed in the fundamental right case. However, during emergency, after a presidential order is issued under Article 359, a law or an executive action can still be challenged on the grounds other than contravening fundamental right specified in the presidential order. The court can take such action to protect the human rights as seen after the effect of the fundamental right case. The 44th Amendment in 1978 saved the Article 20 and 21 from the mischief of Article 359. The effect of the 44th Amendment would protect the human rights to life and personal liberty better than ever before. As regards proclamation of emergency, the chance of curtailment of right to life and personal liberty has been circumscribed by the constitutional provisions, and the judiciary would be able to stand up against the executive, and the courts must appear now to be the protectors of the people's right to life and personal liberty. This was for today. Thank you very much.